Hey, good day yet again. We are now into episode number 2. Welcome to the People's Loctivist YouTube channel. This is Sabelo Banda, the People's Loctivist. Welcome you back as we continue with our topic, your child, your responsibility. As indicated in episode number 1, that the emphasis for episode number 2, which is the episode we are in now, is basically looking inside the no jab, no school regulations that have been proposed by the minister, so that we can understand where the minister is pushing the admission of learners to public schools regulations, which is notice number 3415 of 2025, published in Government Gazette number 53119, published on 6th August. We are now going inside that. We want to hear what exactly the minister is proposing. I am not going to cover all the sections of the Gazette. My primary focus is on the aspect pertaining to the minister saying to the nation, if children are not vaccinated, they should be stopped from going to school. If they are not in school already, they should stay away from school. If they are in school and they cannot produce proof that they have had these immunizations, then they may be barred from continuing with school. So the question that arises is, what exactly does this part say? A brief summary of episode 1, we looked at the legislative aspects, more particularly the constitutional right to parental care, the constitutional right to basic education, the constitutional right to informed consent. We looked at the powers of the minister in terms of the South African Schools Act. We looked at the right to informed consent in terms of the National Health Act. I'm not going to go through the provisions of those acts for this episode. That's just a summary which led us to the point where we are now, where there is this tension, there is this clash between the parents and the minister. If you missed episode 1, I suggest you stop the video here, go back to episode 1, and then come to episode 2. Then you will have a better understanding of how these things build up and lead into each other. So today, our basic context is that we are going deep into these draft regulations. Our major focus being section 14 of the regulations, which part basically says if your child is not vaccinated, they may not be admitted to school. So this is the heart of the debate. Is that possible? This is the heart of the clash that we spoke about in episode 1. The clash between the parents and the state. The clash of parental rights and state overreach. I will read directly from the particular portion of the Gazette that I am talking to, which is section 14 of the proposed regulations, so that you can have a full picture of what it is that I am talking about. Section 14.1 reads, on application for admission of a learner to a public school, the parents must show proof that the learner has been immunized against polio, against measles, against tuberculosis, against diphtheria, against tetanus, and hepatitis B. A parent may apply in writing to the HOD, which is the head of department, education, for exemption, provided the medical diagnosis is supported by a motivation from a healthcare practitioner registered with the Health Professions Council of South Africa, the HPCSA. 14.3. If the exemption is on cultural or religious grounds, the motivation must include proof of past conduct in support of that practice, such as confirmation from a religious or cultural leader. There lies the foundation of the no jab, no score. What does this mean in practice? Really, what does it mean to you as a parent? Well, what does it mean for your child? What does it mean for the nation in as far as the education of the nation is concerned? What does it mean in as far as the Constitution is concerned? What does it mean in as far as other pieces of legislation, like the South African Schools Act, like the National Health Act, like the Children's Act? Where do all these fit into each other? Basically, what this means is that the right to education according to these proposed regulations is becoming conditional. Unlike the unconditional proviso which is in the Constitution. Or better still, the unconditional right which is protected by the Constitution. Now the minister is seeking to make the right to education conditional, contrary to the guarantee of Section 29 of the Constitution, where the minister is now saying to be able to exercise your right to Section 29 of the Constitution, you first of all have to comply with this regulation that I want to pass now. What supersedes the other, minister? Is it the Constitution, or is it the regulation that you are pushing? We now see a scenario where the regulations introduce a gatekeeping role for the HOD. A bureaucratic official is made a gatekeeper of medical exemptions. This is despite the fact that the HOD is not a medical practitioner. We have a crazy scenario here where we have a diagnosis, we have a motivation by an individual who is recognized by the HPCSA, which recognition is informed presumably by the fact that this person has expertise in as far as the medical sector is concerned and can therefore give a proper opinion or a diagnosis on a medical condition. And then you have an HOD being the final arbiter, being the last person to decide whether this exemption is valid or not. What sense does that make? How do you have a non-medical person deciding whether indeed this is the right decision or not, and this is the best possible intervention or non-intervention for this particular child? Further, for reasons best known, regardless of the fact that traditional healers and naturopaths are recognized in law just as much as the allopathic doctors, for some reason the minister has decided that traditional practitioners and naturopaths have no role whatsoever in speaking to any issues that pertain to whether a child can be exempted or not. So now people are being pushed into a particular direction in as far as their medical choices are concerned. This is amazing, particularly viewed in light of the fact that, according to the World Health Organization, no less than 80% of the people in Africa use traditional medicine and naturopathic medicine, which is basically natural medicine, naturopathy and traditional healing combined. We talk to it as natural medicine, which is the original medicine. Allopathy is the alternative. These drugs which are manufactured in a factory, they are alternative. The God-given drugs are the herbs that we have out there, the leaves that we have out there, the medication that the naturopaths are using, and the traditional healers. That is the natural, that is the original. It is not alternative. So now we have a choice being imposed by the minister. We have a total exclusion of other medical practitioners to be able to motivate for exemption. What sense does that make? Why should the entire country be pushed into a corner and have to follow allopathy? This is not to suggest that every allopathic doctor is not as effective. There are some who are really effective. There are some who are really, really good and care about their patients rather. And their primary cause for concern is not necessarily administering the drugs, but it's the patient care. So now, why should the HOD only hear from the allopathic HSPCSA registered medical practitioner and not from anyone else who is also in law authorized to practice medicine? That is discrimination. Just as much as the clash between the parents and the state talks to discrimination against children on the basis of the medical choices of their parents, on the basis of the decisions of their parents, that cannot satisfy any limitation where Section 9 of the Constitution is concerned, which speaks to non-discrimination. So you find that we now have cultural policing. And who is the police officer? It's the HOD. So the HOD is suddenly now given this expertise that no one knows where it comes from. Suddenly, the HOD, over and above being a bureaucrat within the administrative aspects of education, can now make medical decisions. Over and above that, the HOD now has authority to decide the religious grounds upon which an individual can be afforded exemption or not. I put it as being given, not necessarily to say that this has been promulgated. No, it hasn't. It's still at commentary stage. It's still at public participation stage. But this is the kind of power that the minister wants to give to the HOD. This is the kind of expertise that the minister wants to bestow upon an HOD. Further to that, we are told that also to be bestowed upon the HOD is the ability to determine which culture is a relevant culture to therefore be afforded exemption. Which cultural expression, which cultural practice does the HOD know of besides his or her own culture? On what basis does the HOD become authority on everyone else's culture? And it's interesting that the Act puts it this way, the proposed regulation rather. The motivation, this is for cultural and religious grounds, must include proof of past conduct in support of that practice. Okay. Say supposing a parent decides today to convert to a particular religion of his or her choice, and the child has to go to school tomorrow. And then the regulation wants to tell us that simply because you joined yesterday and by looking at your past conduct, you cannot be protected by this religion that you are now part of, even if this particular religion, according to its practice, would have afforded the necessary exemption, or the culture. Who is to decide what this past conduct is? On what basis does the HOD determine how long any particular parent and therefore child can be said to have had enough past conduct? How long is past conduct? How past is the past? When does it start? When does it end for the HOD to be able to determine that genuinely this is the case? This does not make sense. Parents, you need to take a stand. Parents, you need to make it known that this does not make any sense. I dare say, even you as HODs watching this video, you have an obligation to take it up with the minister and say, what you are asking us to do is practically impossible. All that you are doing is giving us more work upon the work that we already have, which work we are already drowning under. You are giving us responsibilities which we are not equipped to deliver on. On what basis can we as HODs take medical decisions? The minister must give you an answer. On what basis can we as HODs take decisions on religion and culture? Again, the minister owes you an answer. So in this commentary period, it's up to you, HODs, to also come to the party. This is not just about the parents, it's also about you. It's about you taking a principled position, not informed by the fact that you have a contract with the department, but informed by the fact that it's the parents who actually make it possible for you to be able to stay in that job. So it's necessary to take a principled position that therefore protects the rights of the children as much as it protects the rights of the parents. When we look further at these regulations, some things you just got to laugh in amazement. I don't know how this came about, but it's there in the regulations. Section 9 prohibits refusal of admission based on unfair discrimination, including religion, belief, and health status. We've just read Section 14, which basically says no job, no school. For you to be able to talk to your culture, to talk to your religion, or talk to your health status, you need special exemption. But Section 9 actually says that you cannot be refused on those grounds. So which is which? Do we go with Section 9 or do we go with Section 14, Minister? Which one basically supersedes the other under these circumstances? Because these, unfortunately, are irreconcilable. And due to the fact that they are irreconcilable, it is impossible to apply. it is impossible to push these regulations through if they have internal conflicting provisions. Not only that, Section 10 guarantees that no learner may be suspended or excluded from school activities or discriminated against after admission. On what grounds? Culture, religion, medical circumstances. So which is which, Minister? Which provision are we going with here? Is it 9 and 10 combined in conflict with 14? Or is 14 overriding 9 and 10? How is that possible, Minister? It would help if we could get some clarity on that particular aspect. So now, we also look at the issue pertaining to Section 22. Section 22 is quite interesting, actually, in a way, in the sense that it now says that a school governing body must assist the head of department in assuring that the requirements for proof of immunization are complied with at the time of admission of the learner. That's not the role of the SGB. The SGB has nothing to do with policing immunization. Again, we are seeing another aspect of gatekeeping now being imposed on the school governing bodies. The HOD is supposed to work with the SGBs to make sure that these requirements are met. What does that mean? What is the basis of that approach? We find that the SGBs, for those who might not be familiar with school governing bodies, is basically the governance of the school through the parents. So it's the parents and the communities who are primarily responsible for school governance, with the principal being the overseer to make sure that everything is done in terms of and according to the law. So now, instead of the SGB continuing in its roles and responsibilities of protecting parental rights and the learner's access to education and the learner's interests, they are now being asked to help exclude children from school. On what basis can we be asking school governing bodies to be part of a process that is aimed at excluding children from school? What is the logic? How do you justify that, Minister? Again, just as the case with the SGBs, your role is protecting learners' interests. Yet these regulations want to enforce through you something which is contrary to the roles and responsibilities ascribed to you in terms of the South African Schools Act. You cannot be turned into state enforcers. That is not your role. That is not your responsibility. You cannot afford to erode the trust between yourselves and the parents, and therefore the trust between yourselves and the learners. So, SGBs, my humble appeal to you, during this commentary period, please reach out to the minister. Indicate in no uncertain terms that, Minister, this role, this responsibility that you want to ascribe to us, no, we are not able. We are not in a position to play that particular role. Ours is to protect the interests of the learners, govern the school in a manner that ensures the advancement of our communities and ensures that our communities are kept informed and we are accountable to the community. It is the parents who have voted us in to be the school governing body. So our first and primary mandate is to those people who have entrusted responsibility upon us. So we cannot, unfortunately, be the state enforcers that you are asking us to be. Parents, HODs, SGBs, it's necessary to stand together for the protection of the children, for the advancement of the interests of the children. You probably ask yourself why this issue matters so much. Over and above the fact that it's about constitutionality, it's about rights which are protected in statute, it's also about government overreach. If government can do it now and start imposing these vaccines on children, what stops them going further in future? What stops them in setting many other conditions which are detrimental to the interests of the children? And in talking about those so-called vaccines, in talking about the diseases that have been listed, I am informed that tetanus B is actually, according to the World Health Organization, considered as a condition which is of no concern whatsoever. It is not a cause for concern. It is just one of those things out there. But the minister is saying it is necessary to vaccinate children for something that is not a cause for concern. What is the real agenda, Minister? Where are you taking us to with what you are putting on the table? Have you interrogated the alternatives to this? Have you interrogated the full implications of Section 6 of the National Health Act? Have you considered the ingredients of all these injections that you are putting on the table and saying parents must put into their children's arms? It would be interesting, actually, to know all the factors that you took into consideration to firstly come up with the list of the diseases that you want immunized against, and further, what you took into consideration as regards the ingredients and the implications of those ingredients, the contraindications of those ingredients, and what procedure has been in place to ensure that the children are not allergic to any of these things that you want injected into them. There is no provision in the regulations for any of the parents to have this information. There is no provision for the HODs to learn about the ingredients, the contraindications, the risks, the dangers. Yet they are expected to take a decision and enforce this thing. There's no provision for the SGBs to also understand what this thing is about. No provision for principals to understand. So also principals, it's necessary for you to communicate with the minister. Your responsibility is ensuring that the SGB operates in terms of the law. So now the law has been put down. The law has been explained. It's up to you now to also support the SGBs and protect the SGBs from the position that the minister is trying to put them in, which is to force them or cause them to be enforcers on behalf of the state. My brothers and sisters, in our next episode, we'll be moving further into charting the way forward. Now that we know that there is a clash, now that we have gone through briefly the terms or the provisions of the regulations, where to from here? What do we do from here? In laying a foundation for episode 3, I'll say, parents, this is your time to act. And the beautiful thing is, in as much as I talk about parents, I talk about HODs, I talk about SGBs, I talk about the heads of schools. Amongst the HODs, amongst the SGB members, amongst the heads of schools, some of you are parents. So you wear more than one hat. So whilst you are thinking as a parent, you are also thinking as an official. And you have to have your voice heard on both aspects, as the parent and as the official. This is for the future of the nation. This is for the future of our children. This is for the future of those yet to be born. The decisions that we take today, whether we decide to act or we decide not to act, that is a decision. That decision has a direct impact on how the children whom we are responsible for are going to experience life. And it has a direct impact on those yet to be born. It's not just about you. You might think to yourself, all my children are grown up now. I don't have to worry about this. I don't have children in school. I don't have children in public school. So why should I bother? This is just for those with children in public school. Life has no guarantees. Circumstances are what they are. You might find yourself with children in public school due to circumstances. You might have grandchildren who end up in public school or start in public school. You might have nieces and nephews in public school. You are part of a community. Within the context of our Africanness, more particularly within the context of Ubuntu, we are responsible for each other. The children of the community belong to the community, and it's the responsibility of the community to protect its children. So don't protect simply because this child will basically come into my house and sleep there because biologically they are mine, or because for some reason or the other they basically put their heads under my roof. Our point of responsibility is informed by our humaneness. Our point of responsibility is informed by the fact that we grow the community, we don't grow individuals. Our point of responsibility is informed by the fact that the success of the community is informed by the health and the education of the community. Let's therefore make it a point that we protect our children. Within our Africanness, your children are my children are your children. We have a responsibility to each other. Thank you so much. Remember, be the best that you were created to be. Remember to like, subscribe, hit that notification button, and share the video. It's necessary, as much as possible, that we get our message out there. We are not fighting, Minister. We are just asking you to reason with us. We are asking you to revisit your regulations founded upon the law of the land. For as long as your regulations are in conflict with the law of the land, they will never see the light of day. I will see you again when we get to episode 3, where again we will be talking to your child, your responsibility. This time we're saying act now to protect his or her future. Your child, your responsibility, act now, protect his or her future. That is episode number 3 coming up very soon. Thank you so much. Goodbye.